I was cross-country skiing across my own property in rural Vermont when I saw her standing at my fence line with her phone pointed at me like she was documenting a crime scene. The woman wore a designer parka that probably cost more than my truck payment, and her lips were pressed into that particular expression that screams HOA president on a mission. Let me back up. My name is Xavier, and I own 47 acres of pristine woodland outside of Stowe, Vermont. I bought the land 3 years ago when I was 32, right after my software company got acquired. The property is gorgeous, with mature maple and birch trees, a small creek, and enough elevation change to make for excellent Nordic skiing in the winter. When I purchased it, there was no HOA, no community restrictions, just pure Vermont countryside with a handful of neighboring properties that kept to themselves. That changed 18 months ago when a developer bought the adjacent parcel and built Maple Ridge Estates, a collection of 12 McMansions that somehow got approved despite the rural character of the area. The houses sold quickly to wealthy out-of-staters looking for Vermont vacation homes, and with them came an HOA that seemed to think their jurisdiction extended beyond their property lines. The woman at my fence was definitely part of that crowd. She waved at me with exaggerated urgency, so I skied over, my breath forming clouds in the February air. "Can I help you?" I asked, keeping my skis pointed toward her but maintaining a respectful distance from the fence. "Yes, you absolutely can," she said, her voice sharp. "I'm Deborah Preston, president of the Maple Ridge Estates HOA. I've received multiple complaints about you skiing across your property." I blinked at her, certain I had misheard. Complaints about me skiing on my own land. "The noise is disruptive, and several residents have expressed concern about the visual impact of ski tracks marring the natural landscape." She held up her phone, which displayed what looked like a formal letter with the HOA letterhead. "We're sending you a formal notice to cease and desist all recreational skiing activities on your property." I actually laughed. I could not help it. "Madam, I don't live in Maple Ridge Estates. I'm not part of your HOA. This is my private property and I'll ski on it whenever I want." Her face reddened. "Your property borders our community, which makes you subject to our aesthetic and noise ordinances. If you don't comply, we'll be forced to take legal action." "Good luck with that," I said, and pushed off with my poles, gliding back across the meadow toward the tree line. Behind me, I heard her shouting something about lawyers and property values, but I was already too far away to care. That should have been the end of it. Looking back now, I wish it had been. 3 days later, I found an envelope in my mailbox. Inside was a formal cease and desist letter from the law firm of Morrison and Associates, demanding that I immediately stop all disruptive recreational activities on my property, including but not limited to cross-country skiing, snowshoeing, and excessive outdoor presence. The letter claimed that my activities were causing irreparable harm to the Maple Ridge Estates community and diminishing property values. I called my lawyer, a guy named Marcus Chen who had handled my property purchase. He read the letter over the phone and made a noise somewhere between a snort and a laugh. "This is complete garbage," Marcus said. "They have absolutely no authority over your property. You're not part of their HOA, you never signed their covenants, and you're on your own land." "Want me to send them a response?" "Please do," I said. "And make it clear that if they keep harassing me, I'll consider it trespassing and harassment." Marcus drafted a beautifully worded response that essentially told them to pound sand. I thought that would be the end of it. I was wrong. A week later, I came home from a grocery run to find a notice taped to my front door. It was printed on official-looking paper with the Maple Ridge Estates logo at the top. The heading read Notice of Violation and Intent to Foreclose. My hands actually shook as I read it. The notice claimed that I had violated multiple HOA bylaws, that I owed over $15,000 in fines, and that if I didn't pay within 30 days, they would initiate foreclosure proceedings on my property. This time, I drove straight to Marcus's office in Montpelier without even calling ahead. "They're completely out of their minds," Marcus said after reading the notice. He was shaking his head in disbelief. "This is so far beyond their authority that I'm actually concerned about the competence of their legal counsel. They can't foreclose on a property that was never part of their HOA." "So what do I do?" I asked. "Nothing, for now. Let them make the next move. They're bluffing. They have to be." No judge would ever allow this to proceed. But Deborah Preston and the Maple Ridge Estates HOA were not bluffing, or if they were committed to the bit. 2 weeks later, I received a court summons. They were actually suing me, demanding payment of fines and seeking an injunction to prevent me from skiing on my own property. The preliminary hearing was set for late March in the Lamoille County Superior Court. Marcus assured me it would be thrown out immediately, but I still felt a knot of anxiety in my stomach. Even frivolous lawsuits cost time and money. The hearing arrived on a gray, drizzly morning that made the courthouse in Hyde Park look even more imposing than usual. Marcus met me outside, reviewing his notes one more time. "Remember, let me do the talking," he said. "This should be quick." Inside, we found Deborah Preston with her lawyer, a slick-looking guy in an expensive suit who introduced himself as Richard Morrison. He had the confident air of someone who thought he was the smartest person in the room. Judge Patricia Holbrook presided, a stern woman in her 60s who had a reputation for not suffering fools. She listened as Morrison presented the HOA's case, which was essentially a rehash of everything I had already heard. I was disrupting their community, diminishing their property values, and refusing to comply with their reasonable requests. When he finished, Judge Holbrook turned to Marcus. "Counselor, I assume you have a response." "Yes, Your Honor. This entire case rests on a fundamental legal fallacy. Mr. Xavier is not now, nor has he ever been, a member of the Maple Ridge Estates HOA. He owns property that predates their development. He never signed their covenants, and he has no legal obligation to follow their rules. What they're attempting here is to extend their private governance beyond their legal boundaries, which is, respectfully, absurd." Morrison jumped in. "Your Honor, the defendant's property directly impacts the quality of life in Maple Ridge Estates. Our covenants include provisions for addressing external nuisances." "Your covenants govern your own properties," Judge Holbrook said sharply. "They don't extend to neighboring landowners who never agreed to be bound by them." "Mr. Morrison, did your client actually believe this lawsuit had merit?" Morrison's confident expression faltered. "We believe that community standards should be maintained." "That's not what I asked," Judge Holbrook said. She looked at the papers in front of her with an expression of clear annoyance. "This case is dismissed. Furthermore, I'm ordering the Maple Ridge Estates HOA to cease all harassment of Mr. Xavier, and I'm awarding attorney's fees and court costs to the defendant. Mr. Morrison, you should have advised your client better before filing this frivolous lawsuit." I felt a wave of relief, but Deborah Preston looked like she had just bitten into a lemon. As we left the courtroom, she followed us into the hallway. "This isn't over," she hissed. "You can't just do whatever you want and ignore the impact on our community." "Actually, that's exactly what the judge just said I can do," I replied. "Stay off my property and we won't have any problems." I wish I had known then what I know now. I wish I had understood that some people, when told they can't have power over you, will find other ways to make you suffer. Spring came to Vermont with the usual mud and melting snow. I spent April clearing brush and planning some trail improvements for next winter. The HOA left me alone, and I started to think the whole mess was behind me. Then, in early May, I got a call from the Stowe town clerk's office. "Mr. Xavier, we have a situation we need to discuss with you," the clerk, a friendly woman named Susan, said over the phone. "The Maple Ridge Estates HOA has filed an easement claim on your property." "A what?" I asked. "They're claiming that the access road to their development crosses your property, and they're seeking formal recognition of an easement right." I felt like I had been punched in the stomach. "Susan, that road doesn't cross my property. It runs along the western boundary, but it's entirely on what was the old Patterson farm." "That's what I thought too," Susan said, "but they've provided a survey that tells a different story. I think you need to come down here and look at this." I was at the town clerk's office within the hour. Susan spread out a survey map on her desk, and my blood ran cold when I saw it. According to this survey, the access road that served all 12 houses in Maple Ridge Estates crossed a 40-foot strip of my property for approximately 300 yards. "This can't be right," I said. "I had a survey done when I bought the property. The road was entirely on the Patterson parcel." "You have a copy of that survey?" Susan asked. "At home. I'll bring it in this afternoon." I raced home and tore through my file cabinet until I found the survey from my purchase. Sure enough, it showed the road entirely on the neighboring property, with my boundary line running parallel but not crossing the road. Back at the clerk's office, Susan compared the two surveys. The discrepancy was obvious. Someone had moved the property line 40 feet eastward on the new survey, conveniently placing the road on my land. "This looks like survey fraud," Susan said quietly. "You need to contact your surveyor and get this straightened out." I called the surveyor who had done my original work, a company called Vermont Land Services. The owner, Tom Briggs, remembered my property. "I'll come out tomorrow and reshoot the boundaries," he said. "If someone's claiming different property lines, we need to get to the bottom of it." Tom arrived the next morning with his equipment. We walked the property line together, finding the original survey markers exactly where they should be, 40 feet west of where the new survey placed them. "This new survey is bogus," Tom confirmed. "These markers have been here for decades. Someone's trying to pull a fast one." "Can you put together a report?" I asked, already planning on it. "I'll have it to you by Friday, and I'll send a copy to the town clerk's office too." When Tom's report came in, it was damning. The new survey had been conducted by a company called Precision Land Surveys, and it contained what Tom called obvious and intentional errors. He had documented everything with photographs, GPS coordinates, and comparisons to historical records. I sent a copy to Marcus, who immediately recognized the implications. "They're trying to create leverage," he said. "If they can claim the road crosses your property without an easement, they can argue that you owe them something or that they have some kind of right to control what you do. It's twisted logic, but it's a negotiating tactic." "What do?" I asked. "We fight back. Hard. This is survey fraud, which is a serious offense. I'm going to file a complaint with the state licensing board, and we're going to send a very clear message to Deborah Preston and her HOA that this kind of behavior won't be tolerated." Marcus was as good as his word. Within a week, he had filed complaints against Precision Land Surveys with both the Vermont Board of Land Surveyors and the Attorney General's office. He also sent a letter to the Maple Ridge Estates HOA, with copies to their lawyer and the town, demanding that they withdraw their fraudulent easement claim. The response was not what I expected. 2 weeks later, I came home to find my driveway blocked by a truck from a company called Vermont Fence and Gate. 3 workers were in the process of installing a chain-link fence directly across my driveway where it met the main road. "What the hell are you doing?" I shouted, jumping out of my truck. The foreman, a weathered guy in his 50s, looked uncomfortable. "We're installing a fence, sir. We have a work order from the Maple Ridge Estates HOA. This is my driveway. You can't fence it off. The work order says this is HOA property and we're securing the perimeter." "Do you have a permit?" I demanded. The foreman checked his clipboard. I'm not sure. We just go where we're told." I called the town zoning office immediately. They confirmed that no permit had been issued for any fence on my property. I put the zoning officer on speaker phone, and he told the fence workers to stop immediately. The foreman was actually apologetic. "Look, man, we're just contractors. If this is a dispute, we don't want any part of it." "Who hired you?" I asked. He showed me the work order. It was on Maple Ridge Estates letterhead, signed by Deborah Preston, and it specifically described the location as HOA property requiring security fencing. After the fence workers left, I stood in my driveway, shaking with anger. This had gone way beyond a simple neighbor dispute. The HOA was actively trying to interfere with my property rights. I called Marcus. "They just tried to fence off my driveway. Are you serious?" His voice was tight with anger. "That's it. We're going nuclear. I'm filing for a restraining order and damages. This is harassment, trespassing, and attempted theft of property rights." That evening, as I sat on my porch trying to calm down, I pulled out my own property survey and studied it carefully. That's when I noticed something I had never paid attention to before. The access road to Maple Ridge Estates did not just run along my property. At one point, where it curved to avoid a rocky outcropping, it actually did cross my land for about 20 feet. It was not the 300 yards the fraudulent survey claimed, but it was something. More importantly, I noticed another detail. The road had been built by the developer on what was originally part of the old Patterson farm. When the Patterson family sold to the developer, they had retained a separate parcel, a landlocked 20-acre piece of woodland. To access that parcel, they had negotiated an easement across what became the Maple Ridge Estates property. But here was the interesting part. That easement had expired when the Pattersons sold their landlocked parcel, and I had bought that landlocked parcel as part of my 47 acres. I sat up straight, my mind racing. If that original easement had expired, and if the access road to Maple Ridge Estates even slightly crossed my property at any point, then the HOA might actually need an easement from me. I called Marcus first thing in the morning. "I need you to research something. What are the exact legal requirements for the Maple Ridge Estates access road?" Marcus dug into it over the next few days, and what he found was gold. The access road had been built with the assumption that it stayed entirely on the development property. But due to a survey error during the original construction, not a fraudulent one like the HOA had tried to pull, but an honest mistake, a small section of the road actually encroached on my property by about 12 feet at its widest point. Even more interesting, the state required that any private road serving more than 10 residences had to have proper legal access, including valid easements for any property it crossed. The developer had apparently overlooked this detail, assuming the road stayed on their own land. "Here's the situation," Marcus explained over the phone. "Technically, that road is trespassing on your property. It's been there for less than 2 years, so adverse possession doesn't apply. The HOA has been using it without permission and without a legal easement. You could theoretically block it off. Can I really do that? I asked. Legally, yes. Practically, it would cause a huge mess. But here's what you can do. You can offer to grant them an easement in exchange for a formal agreement that they stop harassing you. Acknowledge that you're not subject to their HOA rules and pay your legal fees. It gives you massive leverage. I thought about it. Part of me wanted to just block the road out of spite, but I was not trying to hurt the individual homeowners who probably had no idea what their HOA president was doing. I just wanted to be left alone. Let's try the negotiation route first, I said. Marcus drafted a letter laying out the situation. The road crossed my property without permission or easement. I was willing to grant a formal easement, but only under specific conditions. The HOA would drop all claims against me, acknowledge in writing that I was not subject to their governance, pay all my legal fees to date, and Deborah Preston would resign as HOA president. The response came within 3 days, and it was not from Morrison, the HOA's lawyer. It was from a different attorney, one who specialized in real estate law. His name was Stephen Walsh, and he asked to meet in person. We gathered at Marcus's office on a warm afternoon in mid-June. Walsh was straightforward. Mr. Xavier, I've been brought in to clean up this mess. I've reviewed everything, and frankly, the HOA's previous counsel gave them terrible advice. You're right about the easement issue. The road does cross your property, and there's no legal documentation supporting the HOA's use of it. So where does that leave us? I asked. I've convinced most of the HOA board that they need to settle this reasonably. However, Miss Preston is being difficult. She's convinced that giving in to your demands would set a bad precedent. The precedent that she can't harass people who aren't part of her HOA, I said. Walsh actually smiled slightly. Essentially, yes. Look, I'm going to be frank with you. Miss Preston has personal issues with this situation. She moved to Vermont expecting a certain lifestyle, and she sees your property as an obstacle to that vision. She's not thinking rationally. That's not my problem, I said. No, it's not. But here's what I can offer. The HOA will agree to all your terms except the resignation. They'll pay your legal fees, drop all claims, provide written acknowledgement of your independence, and grant a permanent easement in your favor. In exchange, you grant them an easement for the road. I looked at Marcus. He shrugged slightly, leaving the decision to me. I want one more thing, I said. I want a clause that if they violate the agreement, if they harass me or make any further claims about my property, the easement is immediately revoked and they pay an additional $50,000 in liquidated damages. Walsh considered it. I think I can sell that to the board. The penalties will keep Miss Preston in check even if she stays on as president. We shook on it, and Walsh said he would have the agreements drawn up within a week. That should have been the end of it. I really thought it was. The settlement agreement was signed in early July. I granted them their easement. They paid me $12,000 for my legal fees, and everything was documented with the town and the county registry of deeds. For about 6 weeks, I had peace. I hiked my property, worked on my online consulting business, and enjoyed the Vermont summer. The HOA left me alone. Then, in late August, I got a call from my neighbor to the south, an older farmer named Bill Hutchins who had lived in the area his whole life. "Kevin, thought you should know," Bill said. "There's been some activity on the old logging road that runs along your eastern boundary. Looks like someone's been clearing brush." The eastern boundary of my property was heavily wooded and bordered state forest land. There was an old logging road there, barely a trail anymore that had not been used in years. I hiked out there the next morning. Bill was right. Someone had recently cleared brush along the trail, and when I followed it north, I found that it had been improved enough to allow vehicle access. Fresh tire tracks showed that someone had driven along it recently. The trail ran for about a mile through state forest before reaching a seasonal road that connected to the main highway. Someone had created a bypass route around the main access road. I had a sinking feeling about who was responsible. That afternoon, I drove around to the other end of the trail. Sure enough, I found more evidence of recent clearing, and I found something else. A small sign that read Emergency Access Road, Maple Ridge Estates. They were creating an alternate access route. But why? I got my answer 3 days later when I received a letter from the Vermont Transportation Agency. Someone had filed a complaint claiming that my property was blocking public access to the state forest, and they were investigating whether the logging trail should be designated as a public right-of-way. The complaint had been filed by Deborah Preston. I called Marcus immediately. She's trying to turn the old logging trail into a public road. Can she do that? Marcus asked. I don't know, but she's trying. If she succeeds, they could use it as an alternate access and claim they don't need the easement across my property. Marcus was quiet for a moment. That doesn't make sense as a strategy. They already have the easement. Why would they want to get out of it? Then it hit me. Because the easement has the penalty clause. She wants a way to violate the settlement without losing their access. That's actually plausible, Marcus admitted. She could harass you, lose the easement, but still have another way in and out. Can we stop this? Let me make some calls. Marcus contacted the transportation agency and got a copy of the complaint. It was a masterpiece of creative writing, claiming that the logging trail was a historic public access route that had been improperly blocked, and that my property was interfering with traditional use patterns. None of it was true. The logging trail had always been private, crossing both my land and state forest. There was no history of public use, and I had not blocked anything. Marcus filed a detailed response with historical documents, property records, and affidavits from longtime residents like Bill Hutchins, who confirmed the trail's private status. The transportation agency took 3 weeks to review everything, then issued a determination that the trail was not a public right-of-way and that Deborah Preston's complaint was without factual basis. I thought that would finally be the end of it. I was wrong again. In October, as the leaves reached their peak colors and tourists flooded into Stowe, I noticed something strange. Cars were parking along the main road near my property, and people were walking onto my land to take photographs of the fall foliage. At first, I did not think much of it. Leaf peepers are a Vermont institution, and usually people are respectful if you ask them to move along. But the traffic increased dramatically over the course of a week. I started finding trash on my property, and one morning I discovered that someone had trampled through my vegetable garden. Then I saw the advertisement. It was on a website called Vermont Fall Foliage Tours, and it offered exclusive access to pristine wilderness for premium fall photography. The tour meeting point was listed as the Maple Ridge Estates clubhouse, and the photographs clearly showed my property. The tour company was registered to one Patricia Morrison. As in Richard Morrison, the original HOA lawyer, I called Marcus yet again. They're running commercial tours across my property. Are you kidding me? Marcus sounded exhausted. These people are unbelievable. I documented everything. The advertisement, the tour company registration, photographs of trespassers on my property, and even some video I took of a group of tourists being led across my meadow by a guide. Marcus sent a cease and desist letter to the tour company and copied Deborah Preston and the HOA board. The tours stopped immediately, but the damage was done. My property had been trampled. I had to clean up pounds of trash, and my sense of peace was destroyed. "That's it," Marcus said when we talked next. "She violated the settlement agreement. You have grounds to revoke the easement and claim the liquidated damages." "Will that hold up?" I asked. "Let me check the exact wording." Marcus pulled out the settlement agreement and read through it carefully. The tours weren't directly run by the HOA, so there's some wiggle room. But I think we can argue that Preston coordinated this through her husband's law partner, which makes it an indirect HOA action. "What if we can prove she was directly involved?" I asked. "Then it's open and shut." I spent the next week doing some detective work. I called the tour company pretending to be interested in booking a private tour. The person who answered, Patricia Morrison, was happy to explain that they had special arrangements with local property owners for exclusive access. "Actually, I'm friends with Deborah Preston from the HOA," I said, making it up as I went along. "She mentioned this tour business." "Oh, you know Deb," Patricia's voice warmed. "Yes, she's been wonderful. She's the one who helped us set up the routes and get access to the best locations. She really understands the value of the natural beauty out here." I recorded the conversation, with appropriate legal notification that I was recording, and sent it to Marcus. "That's direct involvement," Marcus confirmed. "Preston coordinated commercial trespassing on your property in clear violation of the settlement agreement. We can proceed with revoking the easement." "Let's do it," I said. Marcus filed a notice of easement revocation with the county registry on November 1st. Under the terms of the settlement agreement, the HOA had 10 days to cure the violation, or the revocation became permanent. The response was immediate and dramatic. Stephen Walsh, the reasonable attorney, called Marcus directly. "You're really going to cut off access to 12 families because of a misunderstanding," Walsh said. "It wasn't a misunderstanding," Marcus replied. "Miss Preston deliberately arranged commercial trespassing on my client's property. The settlement agreement was very clear about the consequences. Those homeowners didn't do anything wrong. Then the HOA board should remove Miss Preston and make this right." The HOA held an emergency meeting. I know this because I received a call from one of the homeowners, a man named David Keller, who had bought his Maple Ridge house as a retirement property. "Mr. Xavier, I'm calling to apologize," David said. "Most of us had no idea what Deborah was doing. We've been trying to vote her out for months, but she controls just enough proxies to maintain power. If you revoke that easement, some of us literally can't reach our homes without a mile-long detour on dirt roads." "I'm not trying to hurt you, Mr. Keller," I said. "But she's been harassing me for over a year. I just want to be left alone." "I understand. For what it's worth, we're holding a special election meeting tonight. Several board members are proposing a vote of no confidence. I can't promise anything, but we're trying." That evening, I resisted the urge to drive over and watch the meeting, but David called me afterward. "She's out," he said, sounding relieved and exhausted. "We finally got enough votes. Deborah Preston is no longer HOA president. The board voted to formally apologize to you and to ratify all terms of the settlement agreement. We're also pursuing legal action against her personally for misuse of HOA funds in the previous lawsuits." "What about the easement?" I asked. "That's up to you. We're asking you to keep it in place, but we understand if you want additional assurances." I thought about it overnight. The next morning, I called Marcus. "I want to keep the easement, but I want a new provision. If there's ever any dispute between me and the HOA in the future, it goes to binding arbitration, and the HOA pays all costs regardless of outcome. And I want the liquidated damages clause to stay in place with a 10-year term." Marcus negotiated it with Walsh, and the HOA board agreed to everything. We signed an amended agreement in mid-November. I thought that was truly the end of it. For the second time, I was wrong, but this time the surprise was better. In December, I received a call from the Vermont Attorney General's office. The investigator explained that they had completed their review of the survey fraud case. We're pursuing criminal charges against Precision Land Surveys and their surveyor who prepared the fraudulent report, the investigator said. We're also investigating potential charges against Deborah Preston for conspiracy to commit fraud. Really? I was surprised. I thought the civil settlement had ended everything. Survey fraud is a serious crime in Vermont, especially when it's used to support false legal claims. Miss Preston hired the surveyor and specifically directed them to create a survey showing your property in a different location. That's conspiracy. The criminal case moved forward slowly, as these things do. In March, the surveyor from Precision Land Surveys pleaded guilty to fraud charges and agreed to cooperate with the prosecution. In his statement, he confirmed that Deborah Preston had hired him specifically to create a fraudulent survey that would support the HOA's easement claim. Preston was charged with conspiracy to commit survey fraud, filing false documents, and fraud. Her case went to trial in June, over a year and a half after she first approached me about my skiing. I attended the trial, sitting in the gallery and watching as prosecutors laid out the entire timeline of harassment, fraudulent surveys, frivolous lawsuits, and coordinated trespassing. Preston's defense attorney tried to argue that she was simply an overzealous HOA president who had made some mistakes, but the evidence was overwhelming. The jury deliberated for less than 4 hours before returning guilty verdicts on all charges. At sentencing in July, Judge Holbrook, the same judge who had dismissed the original lawsuit, did not hold back. Miss Preston, you abused your position of trust within your community to wage a campaign of harassment against an innocent property owner, Judge Holbrook said. You filed fraudulent documents, initiated frivolous lawsuits, and attempted to steal property rights through deception. Your actions have cost Mr. Xavier time, money, and peace of mind. They've also damaged the reputation of homeowners associations and cast a shadow over your entire community. Preston was sentenced to 2 years in prison, with 1 year suspended, followed by 3 years of probation. She was also ordered to pay restitution for my legal fees and damages, which by that point totaled over $30,000. I felt a strange mix of satisfaction and sadness as I watched her being led out of the courtroom. I had never wanted any of this. I just wanted to ski on my own land. In August, almost exactly 2 years after the Leaf Peeping Tour incident, I received a letter from David Keller, the homeowner who had called me during the HOA crisis. He invited me to a community barbecue at Maple Ridge Estates. We'd like a chance to start over, David wrote. No strings attached, no HOA business, just neighbors getting to know each other. I almost declined, but something made me accept. On a warm Saturday afternoon, I drove over to the Maple Ridge clubhouse. The barbecue was genuinely friendly. The homeowners, most of whom I had never met, went out of their way to apologize for the previous years of harassment. Several mentioned that they had voted against Preston repeatedly, but had been unable to remove her until the final crisis. We're trying to change the whole culture of the HOA, a woman named Sarah Connors told me. She was the new HOA president, a retired teacher with a gentle manner. We've rewritten the bylaws to prevent any one person from having too much power, and we're focused on maintaining our own properties, not bothering our neighbors. I appreciate that, I said. We also wanted to ask if you'd be interested in a proposal, David added. Several of us are avid hikers and cross-country skiers. We were wondering if you'd ever consider allowing some limited, supervised trail access across your property in exchange for help maintaining the trails. I considered it. My first instinct was to refuse, but these people were not Deborah Preston. They were just homeowners trying to enjoy rural Vermont, same as me. "Let me think about it," I said. "Maybe we can work something out." Over the following months, I did work something out with a small group of residents from Maple Ridge Estates. We created a formal trail use agreement that allowed up to 6 designated individuals to use marked trails on my property for non-commercial recreation. In exchange, they helped me with trail maintenance and even assisted with some forestry work I had been planning. It was not what I had expected when I bought my Vermont property, but it turned out to be a good arrangement. The trail users were respectful. I got help with maintaining the land, and the whole experience actually helped me feel more connected to my neighbors rather than isolated from them. I still cross-country ski across my property every winter, often seeing the distant lights of Maple Ridge Estates through the trees. Sometimes I encounter one of the trail users and will stop to chat about snow conditions or wildlife sightings. The access road still crosses that small section of my land, documented now with proper easements and legal agreements. Deborah Preston served 8 months in prison and was released in early spring. I heard through David that she sold her Maple Ridge house at a loss and moved back to Connecticut. I have not heard from her since, and I hope I never do. The whole experience taught me something important about property rights, community, and the strange things that happen when people with too much time and too much ego try to control things beyond their authority. It also taught me the value of good legal counsel and the importance of standing up for yourself when people try to bully you. Marcus Chen sent me a final bill in September, 3 years after this whole mess started. At the bottom, he had written a note. "Next time you want to buy Vermont property, maybe check if there's an HOA within 5 miles first." I laughed when I read it, but he had a point. These days, I work from my home office, consult for tech companies remotely, and enjoy the peaceful Vermont countryside that I bought this property to experience. The meadow where Deborah Preston first confronted me about skiing is now part of a trail network that I actually share with a few carefully vetted neighbors. The woods are still pristine, the creek still runs clear, and I can still ski wherever I want on my own 47 acres. Last winter, on a bright February morning almost exactly 3 years after that first confrontation, I was skiing across the meadow when I saw someone standing at the tree line. My heart jumped for a second, but it was just David Keller, out for a snowshoe hike on one of the designated trails. He waved and I skied over to say hello. "Beautiful day," David said. "Sure is," I agreed. "You know, I was just thinking," David said. "When I bought my place at Maple Ridge, I thought the HOA would protect my investment and maintain standards. Instead, it nearly destroyed our community and ruined our relationship with our neighbors. It took losing everything to realize that being a good neighbor isn't about rules and enforcement. It's about respect and common sense." "That's true," I said, "but you guys figured it out eventually." "Thanks to you standing your ground," David replied. "If you had just given in to Deborah's demands, she would have kept pushing for more control. Sometimes people need to hit a wall to realize they've gone too far." We talked for a few more minutes about the upcoming town meeting and some wildlife that David had spotted near his property, then went our separate ways. I continued skiing across my meadow, my own land, feeling the cold air and the freedom of movement and the simple joy of being exactly where I wanted to be. That evening, As the sun set behind the mountains and turned the snow pink and gold, I stood on my porch and looked out over my property. Somewhere in the distance, I could see the roof lines of Maple Ridge Estates, smoke rising from their chimneys. They were living their lives and I was living mine, and after 3 years of conflict and resolution, we had finally figured out how to be neighbors. I went inside, made dinner, and settled in for the evening. On my desk was a framed copy of the final settlement agreement, not because I was proud of the conflict, but because it reminded me of an important lesson. Your property rights are worth defending. Your peace of mind is worth fighting for, and sometimes the people who try hardest to control you are the ones who most need to learn that they cannot. The HOA tried to evict me for skiing across my own land. They tried to steal my property rights with fraudulent surveys. They tried to claim authority they never had. And in the end, they learned that when you need someone's permission for something as basic as accessing your own homes, you should probably treat that person with respect. I still have the original cease and desist letter that started this whole mess, filed away in my office. Sometimes I take it out and reread it, marveling at the audacity of someone demanding that I stop recreating on my own property. It seems almost funny now, though it certainly was not funny at the time. The access road is still there, still crossing that narrow strip of my land. Every time I see a car from Maple Ridge Estates drive past, using the easement that they finally obtained properly and legally, I smile a little. Not because I won some victory, but because everyone eventually learned the right way to do things. Vermont winters are long and cold, but they're beautiful too. I plan to ski across my meadow for many years to come, and if anyone ever has a problem with that, well, I know a good lawyer.